Hello and welcome. My name is Cindy Heitzman, the Executive Director of the California Preservation Foundation. Thank you for joining this webinar on preservation law. The format for today's webinar will include an hour presentation followed by time for questions and answers. There is a toolbar on the right side of your screen. If you have a question at any time during the presentation, please type it into the box. Our moderator, Diane Kane, will read your question to Deborah Rosenthal, our speaker, or hold your question till the end for her to answer. Please refer to the audio tab in the toolbar and select if you are listening through your telephone or speakers. To hide or unhide this toolbar, click on the orange arrow, and please adjust your volume on your computer or phone. Today's presentation will be by Deborah Rosenthal, attorney, and will be moderated by Dr. Diane Kane. Deborah Rosenthal devotes her practice to land use and environmental law and litigation with Shepard Mullen Richter, LLC in Costa Mesa. She works extensively with land use and environmental issues in California, including wetlands, endangered species, takings, historic preservation, mitigation banking, and hazardous materials. Deborah has also been involved in a variety of complex federal and state-coordinated environmental permitting programs for large private developments, including the negotiation of development agreements and preparation of development plans. A major portion of her practice is devoted to CEQA, inverse condemnation, and general plan litigation in connection with land use entitlements for large residential real estate developers. She represents clients in complex land use, civil rights, and antitrust litigation in Illinois, New Jersey, Florida, Kentucky, Indiana, and California. Immediately before admission to the California Bar, Deborah practiced as Executive Director of Landmarks Preservation Council of Illinois. In this capacity, she was responsible for supervising statewide preservation advocacy programs. Prior to attending Yale Law School, Deborah acted as a special consultant to the National Trust for Historic Preservation on selected planning issues in Oklahoma and provided special media services to the Oklahoma Humanities Council and the Oklahoma Council for the Social Studies. Deborah currently serves on the Board of Trustees of the California Preservation Foundation. Dr. Diane Kane retired from the City Planning Community Investment Department at the City of San Diego, where she handled large-scale historic surveys as part of the long-range planning process. Previously, she was the Heritage Resources Coordinator for Caltrans District 7 in Los Angeles, where she handles Section 106 and CEQA review of historic properties. As, quote, the mother of the Arroyo Seco Parkway National Scenic Byway in Los Angeles, she has had extensive experience with large-scale cultural landscape documentation and treatment issues. She is a professor of architectural history at the New School of Architecture in San Diego and has taught architectural history and planning at several Southland universities, including San Diego State University, UCLA, and Cal Poly Pomona. As a trustee of the California Preservation Foundation, she is a frequent contributor to CPF conferences and workshops and is a volunteer for the La Jolla Historical Society. Thank you both for joining us.
Well, good afternoon. This is Deborah Rosenthal, and we are going to have a whirlwind tour through historic preservation law. I'm assuming that most of you are generally familiar with planning requirements, but want to know more about historic preservation and how it fits into planning in California. Primarily, I'm going to be talking about buildings. I will be mentioning districts, and I'm happy to answer questions about designating landscapes, objects, sites, the whole variety of cultural resources. But the law is most developed and clearest when we're talking about individual structures and districts. And we're going to go very quickly through the legal basis for historic preservation law, property rights, the different kinds of laws and regulations, and then I want to hone in on the process at the local level and environmental review, which for federal projects and here for all projects in California is very important in all kinds of preservation. Want to be able to talk about how the type of local ordinance that's in place affects preservation outcomes, a little bit of time on special situations, and then questions and answers. And please understand that each of these topics can be a whole session on its own, and so we're going to be going very quickly, and if there's something that you don't understand, please don't hesitate to send in questions. And also, Dr. Kane is going to be a stand-in for those of you who are listening, and will tease out additional information as she thinks it's necessary when we go through these issues.
Yeah, Deborah, can I just jump in here right now and just give a shout out to everyone in the audience? It's a little bit bizarre chatting with a disembodied audience, but we're really pleased to have all of you on the line, and we'd like to make this as beneficial an experience for you as possible. So if you do have any questions, please let us know and we'll get them taken care of. Thanks.
So the first question that we want to talk about is was the title really of this session, which is what is the legal basis of historic preservation law? And the good news on this is that there is strong legal support for the validity of preservation regulation everywhere in the country. The fact that we even continue to ask ourselves this question relates more to the history of historic preservation than to any legal infirmity. I tend to think of preservation as having a mixed architectural heritage. And it helps to understand that there were really two complementary but conflicting theories that came together to form what we know of as preservation regulation and preservation law today. The first is the concept that historic structures and places are something to be celebrated, recognized, acknowledged, that owners should be proud of having historic buildings, and that they have voluntarily undertaken stewardship of these buildings. This is a concept that really came into play the late 1920s, especially in the 1930s, that there should be public recognition of important buildings. Charleston, South Carolina was one of the early leaders in this, and in 1931 it adopted a designation process, but it was simply a review and essentially an advisory process. Frequently designation was considered voluntary, and I think of it as the plaque side of historic preservation, that in essence the local government designates the building because you want them to, and they give you an award or a plaque to put on your door that says this is a special building, and then they step out of it. And that was really what historic preservation regulation consisted of from about the 1930s through the late 1950s, early 1960s. And the second wave of preservation theory was that it's just like any other zoning. It's regulation, there's protection for historic buildings. The government has a role in this, and the owner's participation can be voluntary, but it doesn't have to be voluntary. Participation is mandatory at the decision of the local agency. So someone could apply for designation, but it's not, that's not necessary. And you're really focusing on the quality of the structure, not the attitude of the owner. As Cindy indicated, I do a lot of natural resources work along with historic resources, and it doesn't make, under this theory, any more sense to ask the owner of an historic building whether they wish to be considered historic than it makes sense to ask someone who owns a wetland whether they wish to have the area considered a wetland. And again, Charleston was a national leader in this area. In 1959, they adopted a regulation that required approval for permits. It was toughened in 1967 to give Charleston's board the ability to reject applications. Diane or Cindy, I think there's some noises that might be a little distracting. Chicago also adopted a preservation ordinance in the early 1960s, although it combined both strands and was really an acknowledgement ordinance with some minor regulation sections. Los Angeles also adopted its ordinance in the early 1960s. Hasn't been completely overhauled since that time, and it also has a kind of an uncomfortable combination of these two approaches. So you can frequently see the history of historic preservation in the ordinances themselves. And this is really related to the legal approaches. One is that historic preservation is somehow a sort of artistic luxury. It's voluntary. It should consist primarily of incentives. So there should be a carrot but no hammer. The other is zoning, and zoning itself, there are two different strands. One is the idea that historic preservation regulation is really a form of aesthetic regulation. It's a visual regulation. Now, aesthetic regulation, a lot of it including billboards, but also design review, was upheld in most states by the mid-1970s. So aesthetic regulation is lawful and valid, but it's considered different than land use regulation, which is viewed as having to do with planning and is really more about community character. Those are not necessarily comfortably combined, but I think that you can see in when historic preservation regulation is attacked, frequently the accusation is that it's just aesthetics, or it's just a way to recognize important or beautiful buildings. And the fact is that they've been considered, all of those strands are considered valid reasons for historic preservation. Now moving on to something that a lot of times I don't talk very much about in discussing historic preservation law, because it, in some ways, it doesn't belong in a lecture about how to preserve historic resources. But it is very, very important politically, and in local communities, I think we always hear about the effect of historic preservation on property rights, kind of a drumbeat in the background, that preservation is not fair, that it's not real planning, that it's not a real planning interest. Well, I think the good news is, at least since the 1970s, federal and state courts have rejected that argument. And I want to talk about three cases. They're old cases, although this is a discussion of historic preservation, so maybe old cases are good cases. There are a lot of newer cases, but these cases really laid the groundwork, and they have a very good description of what it is about historic preservation that leads to regulation being considered valid. Dukes against the City of New Orleans, a United States Supreme Court case involving the Vieux Carré Commission in the French Quarter, one of the toughest preservation ordinances in the country and one of the toughest preservation commissions. This was early in the history, and the city decided to ban pushcart vendors from the French Quarter with very few exceptions. And one of the vendors who'd been in business for a while sued, and to be allowed to be there, saying that it was not a valid regulation. And the United States Supreme Court said it's an economic regulation, and we understand that it is critical for New Orleans to protect its tourism. And it says, the record makes abundantly clear that the ordinance is solely an economic regulation aimed at enhancing the vital role of the French Quarter's tourist-oriented charm in the economy of New Orleans. And the state of Louisiana had also given New Orleans the power to adopt ordinances to preserve its distinctive charm, character, and economic vitality. So the court said that in New Orleans, historic preservation means tourism. Tourism is essential for economic health, and that a local government has tremendous leeway in how it wants to regulate for the economic health of the community. There's actually a new case in California this week that applies the same law, saying when it's an economic regulation, you really give the local government a lot of room to maneuver and experiment. So Dukes stands really for the proposition that that when a local government or community can demonstrate that preservation contributes to the economy, that helps support the importance of the regulation and the validity of the regulation. And there's a tremendous amount of information available from the National Trust, the California Preservation Foundation, and local governments about the role of tourism and especially historic tourism. So it falls under the rule of economic regulation. Then Marr against the City of New Orleans, Supreme Court decided not to hear it, decided the same year, just a little bit later, within a month of Dukes, was the Federal Court of Appeal, also involving the Vieux Carré Commission, where they refused a demolition permit for the Domaine Cottage in the French Quarter. And the owner challenged that as an unconstitutional taking. He said it was unfair, and he also said it was illegal to require affirmative maintenance of historic structures. This was, as I said, an aggressive, even though this is almost 40 years ago, this was what we would consider a pretty aggressive ordinance. The owner lost on all counts. The court said there was no evidence that that the Domaine Cottage didn't have value, that it was crucial to the city, and that the city can require affirmative maintenance as long as it doesn't make the property worthless. And it says, an ordinance forbidding demolition of certain structures does not seem on its face constitutionally distinguishable from ordinances regulating other aspects of land ownership, such as building height, setback, or limitations on use. We conclude that the provision requiring a permit before demolition and the fact that in some cases permits may not be obtained does not alone make out a case of taking. And you can see in that statement that the federal court said this is just land use regulation. There's no special category for historic preservation. It's not different from zoning. This is just part of what cities do to plan for their community and to protect their communities. Probably the most famous case is Penn Central against New York City, which was decided by the United States Supreme Court in 1978. This case is still controversial. We sometimes gets called it's the mother of all takings decisions. We're actually expecting another decision sometime before the end of June that will be applying or maybe interpreting the Penn Central case. For those of you who, I'm sure most of you know these facts, but I will remind you that in this case the Penn Central Railroad proposed to tear down, and then they dropped the plan to tear down and proposed to build a high-rise extending many stories into the air above Grand Central Terminal, one of the great architectural landmarks of the country. The community organized to fight this proposal. Ultimately, the application for the demolition of the interior of the building and the new construction was rejected, and it was appealed up to the United States Supreme Court. And the United States Supreme Court, in a decision by Justice Brennan, said historic preservation is a legitimate government goal. It is something that is within the powers of all levels of government, that the building continues to have value, that it was not a taking, and it set up what they call usually the Penn Central factors for deciding when there is a taking. But so it set some standards, but in this case it said the regulation was constitutional. This case is sometimes remembered because there was an air rights transfer where Penn Central was allowed to move its right to build a high-rise from the Grand Central location to other locations in the city so that they wouldn't have a complete loss of the valuable right to build a high-rise. But that was not an essential part of the taking. It was simply approved by the Supreme Court as essentially a good idea to help mitigate the impact of preservation. So we've got, so when someone says property rights are inconsistent with historic preservation, the response is that your property rights include land use regulation. That's simply part of what is involved in modern property rights, and the United States Supreme Court, the Courts of Appeals, and all state courts have found that it is legitimate to restrict uses that would affect historic buildings. So we know it's legitimate to have historic preservation, but what are the governing laws and regulations? What's really in place out there? And I want to talk about 3 different levels: federal, state, and local. The action is really at the local level, and I think that's shown by the fact that all 3 of the cases I just talked about were situations involving local regulations, 2 of them in New Orleans, 1 in New York City. And if there's one thing to remember out of this presentation, it should be that that historic preservation, although it's helpful to have federal and state support and laws, really occurs locally. And in those 3 cases, all of those historic resources were nationally important, but the regulation was local, and the decision for how to preserve the character of the community was local. So we'll start talking about federal laws and regulations because I'd like to spend a little extra time on the importance of local regulations. National Historic Preservation Act of 1966, it was part of the tremendous outpouring of environmental laws in the late 1960s through the mid-1970s from Washington. I think that in a lot of ways this act was a response to some of the abuses of urban renewal because communities across the country did see a loss of historic resources, community character, history, sense of past, and they felt very much that they needed to be empowered to do something about that, and that federal dollars should not be spent for that purpose. So the National Historic Preservation Act remains the main framework for how the federal government approaches historic resources. And that includes Section 106 review, and that Section 106 of the Act that says anytime the federal government is going to build something, fund something, or approve something that's going to affect historic resources, they have to consult about that impact. And they consult, they'll notify the state historic preservation officer, the Advisory Council on Historic Preservation, but anytime there's federal dollars or a federal action involved, there's going to have to be some consultation. The National Register of Historic Places was established. They very reasonably asked themselves, how do you know if something is important if you haven't looked and designated it? So they set up standards for when something could be designated. They established a list. They allowed designation of individual landmarks and also a sort of early view of districts primarily as a collection of structures, especially a collection of structures that is more than a sum of its parts. So a district could be a place that had a sense of place or a community character that that expressed itself visually, even if it wasn't made up of individual landmarks. I worked many years ago in a small area that was almost entirely made up of small, poorly maintained shotgun houses that were not individually significant, but as a collection of houses made a very clear historic district. Originally, buildings could be listed on the National Register without the owner's consent. That changed in the 1970s as a result of a nasty political fight involving a building in Oklahoma City. And so listing on the National Register is voluntary. And this is a place that sort of mixed history comes into play. Because in order to get the advantages of being on the National Register, you have to agree to be on it. But if you are eligible for the National Register, so you meet those standards, you will be treated as an historic building if the federal government is going to be taking any action affecting that building. And as a result of this act, the Secretary's standards for treatment of historic properties were also put together in an effort to decide what kinds of treatment are okay. You've decided this is an important building. You've designated it. How do you know whether you're going to be doing the right thing or the wrong thing? You look at the Secretary's standards. I have to admit that they can be very obscure. Diane probably knows even a lot more about that. But they were a federal effort to figure out when the treatment is legitimate. Another very important section is the Department of Transportation Act of 1966, Section 4F, and that is usually just called Section 4F. And it applies to all United States Department of Transportation programs. And the theory was that the federal government should not be spending federal money to damage national cultural resources. And they certainly shouldn't be doing it without knowing it and without, if there was a choice. So this section provides that property cannot be converted to transportation use. In other words, you can't put a road through it unless there is no feasible and prudent alternative to putting the road right there in that, according to that design, and all possible minimizing efforts have been undertaken. And this applies to parks, wildlife refuges, and for our purposes, historic properties. And those can be public or private historic properties. And this has been tremendously important. Federally funded roads through historic areas are subject to Section 4F, and the Department of Transportation has to look for feasible and prudent alternatives. Federal dollars, for instance, used for the 701 freeway would have been subject to this. There was an important case of a federal road in Georgia leading to one of the Carter Presidential Library that got tied up in needing to avoid impacts. In that case, I think to a park. So if it's a federal road or there's federal money in the road, look at Section 4F. There are many other federal programs, but those are the ones that get used the most often. And one other thing to mention is that being listed on the National Register of Historic Places does not on its own provide any protection except protection from having federal money used to damage the resource. A lot of times there will be popular opinion. I've seen editorials saying this building should not be listed on the National Register because then it can never be torn down. I always hate to say that's not true, but it isn't true. It simply means that a building that has been recognized as nationally significant is being demolished. So the National Register is helpful, and it's part of the recognition strain in historic preservation, but it doesn't provide protections. That's also in large measure true of state laws and regulations. California has its own Register of Historical Resources. It's parallel to the National Register. Generally, if you're on the National Register, you're going to be on the State Register. You can be nominated to the State Register. California also designates historical landmarks. I think we've all seen those signs as we drive around the state. But they are not laws that provide mandatory protections. The State Historic Building Code is worth mentioning. It provides accommodations for historic buildings in complying with building codes, and it's mandatory if the owner requests it. So if an owner wants to use the Historic Building Code, which allows much more preservation of historic fabric and alternate methods of meeting codes, if it's requested, that it has to be applied. There are a number of other state laws and regulations. Section 5024, I believe, applies to state-owned buildings and says that the state should not take any actions or dispose of any of its state-owned property in a way that is going to affect historic resources. There's a 90-page booklet with discussions of state programs, incentives, and designation approaches on the website for the State Historic Preservation Officer and the Office of Historic Preservation. But as I said, state law is not really where the regulation takes place. So I want to talk a bit about local laws and regulations. And there are different kinds of local laws and regulations. The first is a plan. And it's optional in California to have a general plan element for historic preservation that sets forth the community's vision for how it's going to preserve its heritage. And most cities hope take advantage of the economic benefits of preservation. Once the general plan element has been adopted, it becomes mandatory. It needs to be consistent with the other elements, and it must be complied with as projects are approved. So a community that adopts a preservation plan that says we will preserve this street in our downtown then has a, or we will not allow we will not allow development over 2 stories in a particular historic area or near historic buildings. That becomes a mandatory requirement, and it's the way that the community can set the vision and the standards for how it wants to protect community character. Those are generally, obviously fairly general, although there can be specific requirements. Most communities then adopt more specific processing regulations through their zoning ordinance. And typically they will set up rules for individual designations. What kind of designations are we going to allow? Are we going to have landmarks? Is everything we designate going to be of equal importance? Or are we going to allow kind of categories of designations. And then you can have special rules for those individual designations. A lot of cities also allow districts, historic districts, to be designated. And there'll be special rules that identify which buildings in the district are important, which aren't, rules that govern new construction or demolition in the districts. Some communities will have individual designations, but will also control new construction around an individual landmark because of fears that if you have, for instance, a two-story small historic landmark, it can easily be overwhelmed by large construction on either side. It is important to remember that both for the individual designations and the overlay districts, the zoning stays the same, but there can be an extra layer of rules. So you wouldn't typically, if you've got a building that is zoned residential, the fact that it's designated a landmark or in a district doesn't mean that it stops being residentially zoned. The district can allow some flexibility, but it's still subject to the requirement that we have to have zoning districts that set forth the uses that are allowed. So by designating something historic, you don't just remove the restrictions on how it can be used. Typically, what you do is you keep the underlying zoning and require special procedures for changing the appearance of the structures. A lot of zoning, though, can have special exceptions and incentives. It can have reduced parking requirements, increased density. You can change the setbacks. You can approve existing setbacks. You can have, you can change minimum standards. So anything that makes it, that deals with a zoning issue, which would be, density, setbacks, height, building envelopes, that kind of thing. And a particular community thinks needs to be modified to encourage historic preservation can go into the ordinance approving a district. And you can have different kinds of overlay districts and different kinds of special rules. For instance, a suburban residential district would typically need different rules than a high-rise downtown district. A district of, historic district of Eichler ranch-style houses is going to be regulated differently than a downtown area with no setbacks and from before World War I. And then most communities include their preservation ordinances in their zoning, but some communities have standalone ordinances. And that clarifies that you're not changing the zoning by adopting a district, but they need to be carefully done to make sure that they're compatible with the underlying zoning and that they allow appropriate procedures for flexibility, frequently using conditional use permits. So we're drilling down into the the ordinances, which is where the real regulation goes on. And there are a lot of different types of ordinances, older types, newer types. One type is a designation-only ordinance that says, congratulations, homeowner, you have a lovely building and you are eligible for incentives. You're eligible for some tax deductions. And it's sort of no stick, all carrot, and someone can resign from the ordinance whenever they want. Not too many communities have those. A lot of times small communities, especially without a lot of historic areas, may have this kind of congratulations acknowledgement ordinance. Then the next level is to have appropriateness review, which is when if someone wants to change something in a designated historic area or to build something new, put an extension on, really any kind of change, there will be a board that reviews it at the local level. Remember, Charleston, South Carolina had one in as early as 1931, but it was an old-style one where it essentially was advisory. And it might have said, you come through the process, we'll tell you what we think, and then if we don't like what you're doing, we just won't visit your house. So some appropriateness ordinances are very old style, and at the end of the review, it's you do what you want. A number of appropriateness ordinances are delay ordinances, where you come in, you ask for permission to change something or build something new, and the public agency has the ability to say yes, or wait a while and we'll see if we can talk you into changing your mind. That again is the delay ordinances were particularly popular in the 1960s. And then the mandatory ordinances have been more popular in the last 25 or 30 years, where everyone who wants to make an exterior change to a landmark or to an historic district is required to apply for what is usually, although not always, called a certificate of appropriateness. And that's a finding that what you want to do is appropriate. And the ones that probably cause the most trouble are window replacements, where someone wants to replace windows. They have to get permission to do that, and then they're told, no, you need to put in wood windows or windows with a certain number of panes. Appropriateness review can be connected to demolition review, but it doesn't have to be. A lot of jurisdictions have ordinances that say if you want to demolish a designated historic building, go ahead. There are no restrictions. A lot of cities have no restrictions on that. Many other cities who adopted their ordinances, usually in the 60s and 70s, will say that we have 18 months to try and change your mind. So you'll come in, apply for a demolition ordinance. The answer will be, we're going to have a hearing, we're going to have a delay for 9 months, and then if we think there's a chance we can change your mind, it's going to be a delay for another year. So it's very common to have delays of 6 months to 2 years. The third kind of demolition ordinance is where there's a prohibition on demolition unless the property owner can demonstrate that that there's no use of the property without the ability to demolish it. Essentially, unless it's a taking. And I want to stress that this doesn't, the taking standard doesn't mean if your property is less valuable with the historic resource than without it, that doesn't make it a taking. The United States Supreme Court has approved reductions in value as a result of regulation of as much as 95% without holding that it's a taking. It's the question is there some economically viable use of the historic property? Not, is it less money than the owner is hoping for? And I also commend a lot of you to look at the research that's been done on the increase in value in of homes and other buildings in historic districts. So that's the general setup. How does it actually get applied? And what does the public agency do, the local agency? The first step is to adopt a preservation ordinance. What kind of ordinance does the community want? What are the political realities of the community? What are the resources? Is it a community that's post-war? Is it pre-1900? Does it have gold rush buildings? What is it that's trying to be preserved? Do you want a review ordinance? Do you want all incentives? Do you want a strict no demolition ordinance? All of those things should be discussed and decided in adopting a preservation ordinance. The next thing to do is you've adopted your standards, but how do you go ahead in designating the landmarks in the districts? And remember, in a local community, you can designate because of national significance, state significance, or only local significance. So it doesn't need to be internationally or nationally important. It can be an important local school or park or the home of an important local figure in order to be designated. I put surveying the city in because the best practice is definitely to be proactive in determining what buildings qualify as landmarks, what areas qualify as districts, what might qualify in the near future. The Getty Foundation has put a lot of money into helping Survey LA identify historic structures. Surveys need to be updated regularly because buildings that weren't historic when, or known to be important when some surveys are done, might appear in a different light 10 or 15 years later. But it's impossible to have a good preservation program without knowing the facts out on the ground. So that's the proactive piece of it, the ordinance, the designation, the surveys, and then agencies need to review projects as they come in. It's much more reactive. In general, you can't really review them unless there's an ordinance and a designation in place because you don't know what you're reviewing them for. Some communities can require that every building of a certain age be reviewed for historic significance and funnel it into the designation process if it qualifies whenever there's an application. But that requires flagging buildings on the computer system every time there's an application, and doing the preservation application by application is definitely a way to to lead to political conflicts and general unhappiness. So, but in some cases, that's the only way that the review occurs. What is the development process? So when an application comes in, there are a lot of different kinds of applications, and that makes a difference too. The first one are what I call special permits, and those are categories of things. For instance, if you have an historic ordinance that requires certificates when you make an exterior change or put in new windows, you might or might not need a building permit, but you will need some sort of preservation permit. And that needs to be set up and applied for. Building permits, anything that needs an inspection, generally will require a building permit. Demolition permits, pretty self-explanatory. In most cases, building permits and demolition permits are pretty easy to get. There's a checklist to fill out. You fill out the checklist, you go in, and if you filled out the checklist properly, the city has to give you your building permit or your demolition permit. It's considered to be ministerial. And so the city doesn't have the choice. If you want to change your windows, the city can tell you what kind of, can have requirements for safety and how it's done, but ultimately they have to let you change your windows or demolish. If you want to demolish something, ultimately they usually let you demolish it. That's different from a project approval where someone comes in for new zoning, for a subdivision, for a whole new project, a very complex building, and the city has the right to say, we like your project, we don't like your project, or we want your project to change. That's considered to be discretionary. And in a lot of cases, if the city has set it up properly, the demolition of the historic building is part of the application for a new project. So you don't clear the site ahead of time before you go in for the application. You go in for the application and say, I'm going to have to demolish this building if you approve my new project. So the kind of application affects what happens. And then we'll go very quickly through how does environmental review apply. This is something that can typically take 2 days to talk about, and there are conferences all the time that last that long, but on these topics. But I think I can do it in 5 to 10 minutes. So we've got two basic requirements: the National Environmental Policy Act of 1969, NEPA, and the California Environmental Quality Act of 1970, frequently called a little NEPA because it mirrors or parallels a lot of the NEPA requirements. When does NEPA and CEQA apply? When do you need to do environmental review? At the federal level, when you have a major federal action, that's usually, and we talked about this a bit, considered federal construction, federal land, federal funding, or a federal approval. And if it's will trigger NEPA review. In California, it's whenever there's a discretionary project, and that's why I made the distinction between ministerial projects where if you fill out the checklist you get your permit, and discretionary projects where the public agency can say yes, no, or maybe. And that's very important in historic preservation especially. A lot of projects need both kinds of approval, And if that's the case, you can do joint state and federal environmental documentation. The full review of all of the impacts will typically be an environmental impact statement at the federal level, an environmental impact report at the state level, and that's when a project is going to have some significant adverse effects that can't be avoided. If its environmental review is required, but the project will not have any significant adverse effects, you can do a negative declaration at the state level or a FONSI, finding of no significant impact, at the federal level. But the state especially has lists of exemptions where either the state legislature has said, we choose not to have environmental review for this, for instance, the 1984 Olympics, or we choose, we think this is a category of projects like single-family homes that typically don't apply to projects with demonstrated impacts. But exemptions, the exemption that as a category of projects that typically don't have environmental impacts. However, exemptions typically don't apply to projects with demonstrated impacts. So for instance, I worked on a project that was very, very small, and it was it would have been exempt from CEQA, and it didn't, because even though it was discretionary, it was the type of project that would typically not have an environmental impact, and I didn't need any federal permits. So we figured there was an exemption, but the public agency decided that it was an historic structure and that the exemption did not apply. So always remember, if there's an exemption, but it looks like it's going to affect an historic building, that exemption arguably won't apply. So when you're doing the environmental review, the first thing you need to do is, if you have an historic resource, you have to identify significant adverse impacts. And in California, if a project will comply with the Secretary's standards for treatment of historic resources, the legislature has decided it won't have significant adverse impacts. If it is going to have adverse impacts, you have to look at ways to avoid or reduce those impacts, to mitigate them, either a smaller project or a project that incorporates the historic building, or you have to look at alternatives to the project. Whether can it be done somewhere else? Can it involve moving the building? Anything that could be considered a way of protecting the historic structure. It's also important to remember that historic resources do not need to be designated in advance for CEQA to apply. But it is a much better practice to have them designated, because a lot of times if you are going to impact a building, no one will know it's historic if there's been no survey, and it gets simply written off unless an historic or cultural report is required. So in California, even if it's not designated, you can have a building that is eligible for the National Register, eligible for the California Register. It can be on a local survey. It can be designated locally, but it can also be on a local survey that meets the test for professional surveys. So you wouldn't typically have a group of Boy Scouts going out and surveying historic buildings and, turning in the crayon written survey and have that be an official list. But there's a well-known case involving Montgomery Ward out of Oakland where a building was listed on a professional level survey that had been accepted by staff but had never been vetted at the public level. And nonetheless, it was considered to be an historic resource, and the project called for demolition. So so the decision was made that it was an historic resource once the application came in. So you've done your environmental review. What happens? And this is a place that people in other states always have a lot of trouble understanding what goes on in California land use. Under NEPA, the requirement is that you have to take a hard look at impacts, mitigation measures, and alternatives. And the assumption is that if you take a hard enough look, you'll probably want to preserve the historic buildings. But if you don't, it's a policy decision, and the courts are not supposed to interfere. That is not the case under CEQA, and this was decided many years ago, 15, 20 years ago, that if you have a significant impact, and if that impact can be reduced, it doesn't have to be avoided, can be reduced by a feasible mitigation measure or a feasible alternative, the public agency has to adopt the alternative or the mitigation measure. The public agency can't say, it's feasible, we just don't think it's a good idea. Or it's feasible to avoid or reduce the impact on this historic building, but it's going to cost $200,000 to do that, and we would rather have that $200,000 spent on something else. If it's feasible to reduce the impact on the historic resource, the public agency has to do it. If it's not feasible, the public agency can approve the project with a statement of overriding considerations. So the public agency can say, we hate to lose this historic building, there's nothing we can do about it, and there are enough public benefits that we're going to go ahead and okay the project anyway. They don't have to. It's voluntary on the part of the elected officials. And it's also important to remember that even if the mitigation is not feasible, if you have a general plan requirement that says this will be protected, or the zoning says it will be protected, CEQA doesn't override the general plan. So a general plan that says all landmarks will be preserved, it doesn't matter if CEQA says it's infeasible to preserve the landmarks, you have to follow the general plan. Other federal review requirements we talked about a little bit earlier. Federal Section 106, the federal agency has to talk to the historic agencies, and Department of Transportation has to consider historic impacts. So what has to be assessed in the EIR? The first thing to remember is, as I said, it doesn't have to be a designated historic resource. In fact, you don't even have to be positive that it is an historic resource. There just has to be a fair argument that it's historic. There was a case out of Monterey where the public agency refused to designate a jail for what were thought to be political reasons. The local preservation community brought in evidence that it was historic, and the court said, taking into account what the preservation organization has said, we're going to require the agency to do environmental review because we think there's a good enough chance this is historic that we should at least know what the impacts are going to be. You then, once you've decided that it qualifies as historic or potentially historic, you have to look at potentially significant adverse impacts. Those can be impacts to the structure. I would mention that it might not be that if you've got an historic resource, it should be impacts to the historic character, to the character defining features. If it's a craftsman's cottage that already has aluminum siding on it, the fact that the project is going to take the aluminum siding off is probably not going to be an adverse impact to an historic resource. It can also be an adverse impact to the setting of the historic structure. That can be the landscape around the building. It can also be in the district, a district. And this is not necessarily going to be the same thing as an ordinance. Sometimes you'll have an ordinance that has very, very strict requirements for what can happen anywhere in an historic district and what kind of new requirements can be, new construction can be allowed. And that may be a little bit different than figuring out whether what's being proposed is going to have a significant adverse impact. Because the ordinance just sets the rules. It doesn't, it assumes it's going to be adverse. Worth mentioning mitigation for historic impacts. Taking pictures of historic buildings is generally, but not always, inadequate. Take out the space there. That was the case out of Oakland where it was held that taking pictures of that building was not adequate as mitigation, and there was still going to be significant adverse impacts. But I can think of times when photo documentation is appropriate. I think, for instance, I worked on a project where the interior construction methods, the joists, was an experimental form of engineering, and drawings and pictures might be adequate in that situation where you really couldn't, they weren't visible to the public anyway. Preservation is always a mitigation measure. It may or may not be feasible. Money can be required to be spent on preservation. You can't totally prevent the objective of the project, but you can require that a building be maintained, restored, moved, incorporated into a project depending on the project. And then, of course, if it's not feasible, a public agency can refuse to override the impacts. Feasible alternatives to historic impacts, again, if they're feasible and they reduce impacts, they're mandatory. Economic feasibility can wind up being a big issue in both under CEQA and under an ordinance. It does not have to be addressed in the EIR itself. There have been a couple of cases on that. And that's a situation where an owner wants to show that there's a taking of property, that it's too expensive to preserve, that no use, economic use of the property can be had if they have to preserve the property. The Emporium up in San Francisco was a project where the owner and the city agreed that only the facade needed to be preserved, that it was too expensive to preserve more than the facade. And it was held that the economics did not have to go into the EIR, but that information had to be made available to the agency and had to be available for public review, because if the city wanted to find that something was economically infeasible. And I just mention that feasibility under CEQA tends to mean reasonably likely to happen, that a project isn't feasible if it won't attract any investment, if it won't happen because so little money can be made. That's different from the test undertakings, which says there's no economic use of the property. So they're slightly different rules, although the ordinance can incorporate the taking either one. So that can be a bit of a trap for the unwary. What is the relationship between the local ordinance and environmental review? And I really want to stress this, because this is where a lot of local agencies and communities get into trouble. Unless a local ordinance gives discretionary authority, environmental review is not triggered. So you can have an ordinance that says we will preserve any designated historic structures, but demolition permits are non-discretionary. That means that no matter how important the building is, if it's not already designated, the owner can get a demolition permit. Now, a lot of cities address that, like Los Angeles has something in their building permit that says, essentially, if you would be considered an historic resource under CEQA and you come in for a building permit, it's discretionary. So there are a lot of ways to address that, but the public agency needs to do that ahead of time so that the community and the city council and the city attorney don't wind up in a situation where there's an argument about whether you can have an emergency moratorium to stop someone from getting a demolition permit overnight. So demolition permits are especially problematic, but the courts have made it clear that it doesn't matter how important the building is. If the city doesn't have the review procedures in place, it can't prevent issuing a demolition permit. And then local ordinance, this is a bit of a hobby horse of mine, that local ordinances should consider and complement CEQA, and the timing under a designation ordinance and a review ordinance should be compatible with CEQA, and someone shouldn't wind up in a process that takes 3 years to go through CEQA, and then you wind up going through a local review process on its own, separately, at the end of the day, or vice versa. And then very quickly, are there any special situations? Yes. Religious structures, state law exempts religious property from designation unless the owner consents, but there's still some ways to approach it under CEQA. Density transfers and bonuses are authorized by state law, and CPF does sessions on bonuses and incentives pretty regularly that are worth listening to. And then finally, publicly owned property. The way it's supposed to work in California is that if you have state-owned property or a property that was acquired by the state, you are supposed to be considering historic impacts. And I encourage folks to look at the redevelopment properties that are being disposed of for whether they are historic properties or not, and demand that the public agencies consider impacts on those buildings. The theory all along here is that public money and approval at the federal, state, and certainly local level should not be given to projects that destroy our cultural heritage. And all levels of government are asked to look at the effects of their actions. So I managed to get through without Diane interrupting me, unless she's been waving at me and I didn't notice.
No, Deborah, you've done just great. We have not received any questions, so if people have questions, now is the time to bring them forward. I'd like to start off by kicking one to you, which is you mentioned the flagging of properties identified in a survey as evidence for CEQA review. Do you have any further insight into what standards those surveys need to maintain in order to be taken seriously by the courts?
Well, there's I don't have it at my fingertips, but it is in the state law. It outlines, it requires surveys that meet certain kinds of standards, and I can try and find it, but it generally needs to be a survey that collects certain kinds of information, has people with certain kinds of training, and but one of the things that can be done is you can have a survey that in essence triggers individual review for whether something is historic or not. So the main purpose of all of this is to avoid a situation where, because a city's designation process is very limited, that you miss a lot of properties. So you can identify them on surveys. You can have them on lists that would trigger a survey when an application comes in, or you can have flags for buildings over a certain age, and then the property owner is required to submit information about whether it's historic or not. That can sometimes be considered a burden, because somebody comes in to do something with a small building and all of a sudden is met with a requirement to hire a professional, and if you do a professional level survey, it avoids that kind of issue.
Yeah, I've worked on a lot of surveys, and it seems as though there is a constant misunderstanding about what a survey is and how it's used by people who are sensitive to private property rights. Because the issue seems to be, well, if I'm identified in the survey, that means I can't ever do anything with my building, and I don't want to be part of your survey. We had a lot of issues in San Diego when I was working on surveys where we were doing a broad brush look, just trying to get opportunities and constraints analysis to be proactive so people would know where the potential development could go and where it was unlikely to be favorably looked upon, and wound up getting clobbered by both sides, both the preservationists and the development community, because the baby hadn't been split properly. So the bathwater got thrown out and the baby with it. So
and that definitely can happen. Property owners can be very sensitive about being on a list which they feel has legal consequences without having notice of that. But on the other hand, information collecting has to start somewhere. And to the extent that it is good quality professional level information collection, the agency needs to be able to do that. And then once the agency decides to do something with that information, then notice needs to go to the property owner. And if the property owner has information to rebut inclusion on the survey, fine. But the courts generally feel that as long as there is a process for the designation, they're not going to push. They're not going to push all the way back to the first time you go out and do a windshield survey for buildings that look like they might be over 50 years old and in a significant style. They're going to say that's the kind of thing the city needs to be able to do. And the other choice then is to require that every applicant who comes in come in with an historic study.
Yeah, and in that case, at that situation, you're putting all of the responsibility for evaluating not only that individual property, but for providing a context for the property's significance that is really a huge burden on the property owner. So rather than relieving property owners of an economic burden of doing all that additional research privately for an individual building, it's much more advisable to have an area-wide survey where you can look at an array of structures within a number of different contexts to get a sense of relative significance for historical designation purposes. So I guess I would just be very strongly in favor of doing as much of this information ahead of time before a project comes in, so you have a better idea of where you stand. But just from a political perspective, it's both very costly to do surveys, and there can be a lot of misunderstanding about how the information is being collected and how it's going to be used to make them sort of a problematic field to go into, even though what you're trying to do is to be proactive.
Diana and Deborah, we have a number of questions that have come in.
Okay, yeah, I'm not getting any of those, Cindy. So if you
okay, I'll read them. I'll read them to you. First question that came in is, what fiscal or economic standards should a local jurisdiction use when a religious organization requests relief from local historic preservation policies based on economic impacts and or impacts to the practice of their religion?
Well, there are a couple of, that's a pretty complicated question, and I think the answer is that the courts have typically rejected the idea that it's going to cost, that it's not allowed to have a land use regulation because it's going to cost a religious organization some amount of money to comply that they would like to spend on something else. However, there are two things. One is that in California, you can't designate the buildings as historic, so they don't go through the designation process. You may be able to have some general plan requirements, and in that case, the standard that you would be looking at is the standard under the Religious Land Use and Institutionalized Persons Act of 2000, which is a federal law which was intended to implement and reapply the First Amendment to land use decisions. And what it says is you can't apply any land use regulations that have a substantial burden on an organization's, a religious organization, the exercise of religion. And that's been interpreted not to have a very economic aspect, but really to be looking more at the idea of what do you need to do to practice religion. You need to be able to meet. You need to be able to have educate children. You need to be able to worship in a large enough area. But there's no economic standard, and I would recommend that if religious organizations are causing problems, that the city attorney needs to be consulted, and someone, I do a fair amount of RLUIPA analysis, but there are a number of specialists who can assist the city in identifying the boundaries of preservation and religious exercise.
Okay, Cindy, I'm getting the questions through now, but are we out of time? Hello? Hello?
Well, I'm still here.
Okay, well,
I'm still not getting questions.
Okay, well, Deborah, here's a quickie. What was the case in Oakland that deemed photo documentation inadequate mitigation, and where would we be able to find that decision?
The name of that is...
it's the Montgomery Ward case, wasn't it?
It was, but that's not the name.
It was a name. Okay.
That something like, it had a very long, complicated Society for the Preservation of Historic. If somebody just wants to email me, I'll send them the name of the case.
Okay. We are writing a new ordinance from scratch, and what are 3 quick tips to avoid pitfalls?
Well, the first is to have a very clear idea of what you want to accomplish with the ordinance, and it sounds like a good thing to be doing. So do you want, what kind of ordinance do you want to have? And be prepared for the political issues that are likely to come up, and make it simpler rather than more complicated.
Yeah, I would agree with the political issues. Very definitely do outreach way in advance and bring all of your stakeholders into the process early in order to avoid surprises at the tail end. You really do not want to get to your planning commission or your city council and have a bunch of armed opposition. It's not pleasant. Okay, are there special situations for emergencies of public structures, such as failing foundations or bridges, I guess, for demolition permits?
Typically, yes. Typically, a lot of ordinances have emergency provisions, and a lot of times it is infeasible to preserve those structures or preserve their character or defining features. But it is important not to get bulldozed or rushed by inappropriate arguments that a building needs to be red tagged. There were a large number of buildings after every earthquake. There are buildings that are red tagged, or buildings where the demolition application comes in, where the buildings are actually feasible to restore. So any kind of health and safety, you need to move people out of those buildings. Public infrastructure can be repaired, but there needs to be planning ahead for disasters that allows cities to have teams to go out who are knowledgeable to assess whether it truly can't be restored.
Yeah, I just got back from Cuba, and I was absolutely astonished by the number of very old pieces of failing historic fabric that are very lovingly and carefully shored up to preserve whatever pieces are still extant. So there are ways to keep things protected while you are trying to figure out how to deal with them, rather than just hauling everything off to the dump in a knee-jerk reaction. Final question, what are your thoughts on owner consent and the politics at the county level?
I'm sorry, could you repeat that?
Sure.
About owner consent?
Basically, owner consent and counties versus cities.
Counties are subject to the same requirements. Owner consent is not required except for religious structures. And I think if you view it as a zoning regulation, the allowing owner consent is inconsistent with the premise that the regulation is required for the public health, safety, or welfare. So counties are subject to the same, have the same rights and the same obligations and responsibilities in regulating for historic structures.
So basically, there's not a lot of difference between a city and a county regarding their historic property and preservation options.
No. No.
Okay, here's another one. How can the public be assured that the agency will follow the rules set forth in an EIR if a new construction project site contains historic artifacts?
Well, what the public agency is supposed to do is adopt a mitigation monitoring plan under CEQA and frequently enter into contracts with the developer. But the mitigation monitoring plan should have an assignment of responsibilities, timing, and a way of checking up on what has occurred. That was a big problem with implementing mitigation measures in the 80s and 90s, and the mitigation monitoring plans were added as a requirement specifically to provide assurances that the mitigation was going to be implemented.
Yes, as someone who's written a number of EIRs and EISs at both the federal and the state level, I would encourage all of you who are listening, if you either write these documents or you review them, to really look at the mitigation as it is presented in the documents and tag every requirement to a specific agency or entity that is responsible for fulfilling it, plus a timeline and some feasibility structure for funding or providing whatever resources are called for to make sure the mitigation actually happens. Because I've seen all sorts of mitigation written that just never gets carried out because the way it was set up in the original document was flawed.
And there are sometimes EIRs that are written where you can't tell who's responsible for a
Correct.
mitigation measure.
Exactly.
And
then,
that's
yeah.
a violation of CEQA. CEQA is supposed to have every mitigation measure clearly assigned for responsibility and a timeline and deadlines.
Absolutely. Well, unless we have any further questions, I think we have run through the list.
We have, and I want to thank both Diane and Deborah for taking time out of their schedule to speak today, and thank everyone who attended for joining us today. You'll receive an email with a link to a survey, and we would appreciate any feedback on this webinar and recommendations for future topics. This is very important to us as we plan our schedules for the year. And if you're not a member of the California Preservation Foundation, we encourage you to join as an individual, as a nonprofit organization, government, or a corporate member. Each member receives benefits, including discounts to all programs such as these webinars and workshops, our annual conference and awards programs, and of course our members-only tours. Your attendance at this program helps us fulfill our mission to provide leadership to protect California's historic sites and communities through education and advocacy. You can get information on our website. And I want to thank you all for joining us, and you all have a great afternoon.